keep hearing about these invisible risks in service contracts. They only show when a client is ticked off. Can you please shed some light there?
Again, a very good question. This is, all of us, when we sign business agreements and we win large opportunities and orders, we all celebrate. But at the same time, we sign up some important documents with the client, and these are called by different names. These are called non-disclosure agreements. They're called master services agreement or statement of works. All these documents contain, terms and conditions. Some of them are commercial terms and conditions, some of the legal terms and conditions. To name a few terms and conditions, it would mean probably confidentiality, intellectual property, indemnity, or data privacy. Some of these are terms which you're expected to comply with, and some of them have a global regulation impact, right? Data privacy law, has been recently, cleared by cabinet in India, so that it will become much more stringent compared to what it was a few years back. So these are the risks which you sign up to. Now, when you sign up to these risks, what mechanism have you put into place in order to protect yourself, right? Is it that you sign it and then hope nothing will happen? And then, and then one fine day, something untoward happens, and then the client sues you for a breach of a particular obligation, and then you are in trouble. So what you do, again, artificial intelligence comes to a rescue. What it does, it basically keeps you aware of what is the risk you have signed up to. What is the risk? What are you supposed to do with that? What are the action you should do in order to mitigate that risk? Let's take an example. I spoke about confidentiality. The confidentiality is like this, that let's say you employ 100 people in your company. You as a company have signed the confidentiality agreement, which means that you will keep the client's information confidential. Now, you have 100 people who work for the client. Now, do they know about this obligation which you signed up to? You knowing alone is not enough, or your lawyer knowing this is not enough. Each of the engineers need to know. Now, how do you do that? Unless you train them, unless you explain to them what it means, how do you handle the information, how do you protect it? And then also, after giving them necessary education and training, you must get them to sign a declaration. Now, written declaration means that I will say, look, I am Deepak Jain. I have understood what you are telling me, and I hereby confirm that I will comply. This puts an additional pressure on the individual to stay alert and stay compliant. So this is something which, again, artificial intelligence come to your rescue in guiding you on time to time, helping you know where you are you missing something. Any employee who has not signed a document will come to your notice well before.
But what about the employees that have left the company?
See, unfortunately, the law will not bail you out on that. The law expects you that even if you have, let's say you sign up a non-disclosure agreement or a confidentiality agreement, which is valid for 3 years till 2026. Now, if the employee has quit this year, you are bound by till 2026 for the confidentiality. So you have to make sure the exiting employee also signs a sort of undertaking saying that, look, even if he's leaving your company, he will still uphold the criticality or the confidentiality information, even in wherever he is going or wherever she is going. So your liability remains, and therefore you need to make sure you communicate this to the exiting employee. You make sure he understands or she understands, and again get a declaration signed by him or her so that you have an additional measure of communication and protection.
Our agreements limit our liability, right? That means we are safe.
I wish we were safe, but certain legal condition which I mentioned to you, for example, intellectual property violation or data privacy or confidentiality, the liability can go beyond the contract value. Let's say you may have signed a contract worth 1 crore rupees with a company, but if one were to breach any of these specific terms, then the client may sue for multiple times of 1 crore. So it could be 3, 4, 5, 10 crore, depending on the impact the client has had. So I would say better to be safe than sorry. So use AI. You have the mechanism available today to drive your obligation on a continuous basis or a proactive basis, and be prepared. And once you're prepared, I'm sure these risks will not bother you at all, and you can have a peaceful sleep.
Thank you very much.
Thank you. Nice talking to you.